Good day, everyone. Thank you for joining us at the BCCDC Homeowners Conference. I hope you are enjoying yourselves and learning much from the programs. Today, we will be talking a little bit about estate planning, wills, and trusts, which are important to everyone, particularly those who are homeowners now or who plan to be homeowners in the near future. We will begin the presentation. So, estate planning, you may ask, what is it? Well, there's different kinds of estate planning. There's some estate planning that has to take place during your life. For example, what happens if you become incapacitated? Who's going to handle your financial affairs, operate your business, pay your bills, pay your rent, take care of all your financial matters, pay your insurance, pay your taxes, and so on? Who will provide for your physical needs? If you need to go to the doctors, you need to have physical therapy, who will make healthcare decisions for you? That's during your life. Also, estate planning involves what happens after your death. And one is who is to receive your estate, which is important. What portion each is to receive. Everybody get equal, some get more than others. I should remind you that it's a big issue. Sometimes parents are concerned about giving children equally, particularly where they have maybe helped support one child. So there's a lot of discussions that should occur around that. Specific items. There may be some specific sentimental items, personal property, that you would like one person to get, and that is taken care of in your estate plan. Outright distributions are hold until a certain age. Most of us have come to the conclusion that even a relatively modest estate is just too much money for an 18-year-old to handle and deal with property, so we can stretch it out until they're old enough to handle it. You can make charitable contributions. It's a good time to make charitable contributions to some organization that's important to you, whether it be religious or educational. And you can provide for disabled relatives without them losing any qualified benefits that they have. You can also protect your children from prior marriages. Today, many marriages have his, hers, theirs, children, and here's a chance to protect them. You can avoid probate, and we'll talk about why that's important in a bit, and minimize or eliminate the estate taxes. If you have no estate plan, then the burden is on your loved ones. They're going to have to deal with all of this, and it is going to be quite a mess. If you become incapacitated with no plan, you may need a conservatorship. Conservatorships are expensive, lengthy, embarrassing. You got to go to court. It's just a process you'd rather not go through. And if you have no plan, the state of California has made a will for you. It's called intestate succession, and it will determine who gets what, when, and where. Plus, there's excessive probate costs with no plan. Now here's the tools. These are the basic tools. There's wills, trusts, durable power of attorneys for health care, retirement pension plans. You got to look at family dynamics, which we'll talk a little bit about. And you have to review your estate plan from time to time because life changes, people change, and you want to look at it from maybe every 3 to 5 years and have it checked. So the recommendation, of course, is plan your estate. And so one of the first things we'll talk about is the durable power of attorney, which we all can use, regardless of the size of your estate. You want to have a durable power of attorney. And what is this? It's authorized by statute, and it's exception to the general rule. The general rule is if you just have a power of attorney, it expires upon your incapacity. This is an exception. Special language makes this go working while you're incapacitated, which is important. And it does expire, however, on death, so the power of attorney isn't going to take care of what happens to your assets after you pass away. And there's a couple of different durable power of attorneys. One is to manage your property and personal affairs, and the other deals with your healthcare directives. We'll talk more about that. The California Probate Code sets forth your durable power of attorney, the required provisions, and you can choose to make it effective immediately, giving your agent immediate authority to sign your name on important documents, or only on your incapacity as determined by a physician, and appoints a person also to handle your property, financial matters, and your personal care. Okay, and the typical subjects, they can deal with your real property, they can buy, sell, insure, repair for you if you can't. Same with personal property. They can sell your cars, insure your cars, repair things, handle all your investments, your bank accounts. So the durable power of attorney is important if you become incapacitated. It is an important tool. And the Advanced Healthcare Directive is similar, but it deals with your healthcare. And California provides for the Advanced Healthcare Directive. And it usually takes effect on incapacity, but it appoints a person to handle your healthcare matters. And in one document, there's the power of attorney, so that your agent can talk to doctors, look at records, get second opinions, and make healthcare decisions for you if you can't. The document also sets forth your own personal healthcare instructions. So, wills, and just go back a second on that. Let me just mention your personal healthcare decisions, and certainly end of life, whether you want to be, kept alive for as long as possible, whether once you are a persistent vegetative state, they can stop feeding you, and so on. You really get a choice of what you want to do in your healthcare directive. Also, your burial instructions you can contain in there, and you know what kind of you want to stay involved with your churches, your temples. It's all set forth in there. And so it's a very, very important document. Whether you want to make anatomical gifts, it's all in there. So that's the healthcare directive. Now we're going to talk about wills, which you've probably all heard about. And a will is a legally binding instrument that governs the disposition of your estate at death. And it's revocable. The person who creates a will is called the testator, and you can revoke it at any time, amend it, change it prior to death. And a will also, very importantly, designates who's going to be the guardians of minor children. The will is the appropriate document for that, whether or not there's a probate. The designation in the will of who's the guardian for minor children will govern. So that's an important aspect. Okay, the disadvantages of obviously it only takes effect on death. It provides no help during your incapacity, not going to do any good at all, and it must be probated. And we'll talk about how horrible that is. But unless everything goes to your surviving spouse, or your probate estate does not have real estate more than $50,000, and it has less than 184,500, which is just changed from the 166. So if you have less than 184,500, no real estate more than 50,000, you don't need a probate. It's a very simple sort of affidavit procedure. The other disadvantage of a will is its outright distributions. There's no opportunity to stretch the money out or the assets out over a person's age, but you can put a trust within the will, but that's usually never recommended because you still got to go through the probate process and then establish the trust. So probate. We talked about probate. Probate is something you'd like to avoid. And why? A couple of reasons. One, it's expensive. These are the statutory fees set by statute. So a $1 million estate, it's $46,000. But the real downside to probate is not just the cost, plus there's additional costs, by the way. If there's going to be a sale of a house, a sale of a business, those fees will increase dramatically. But the other problem is it takes about a year, the process. It's through the courts. That could be a mess, especially if courts get shut down from time to time. And it's public. So everyone will know exactly what you have and who's getting what, when, and where. And if you have relatively young children and you pass away, they will be getting calls from the Ferrari salesman. And you'd like to avoid that. So probate is something you'd like to avoid. So how do you avoid probate? Several ways. One is you can have joint tenancy, or if you're married, community property with right of survivorship. We'll talk about the pros and cons of that, but that avoids probate. You can have pay on death accounts with your investment accounts, your checking accounts, your savings account. Simply provide in there who your beneficiaries are if you pass away. They come in with a death certificate and they're given the funds in the account for the investment. Life insurance avoids probate, and your retirement plans avoid probate, and a living trust will avoid probate. So, trust. Assets transferred to a trust during your life are not part of your probate estate. You want to look at your title policy, and most title policies do provide that transfers to a trust are fine, keeps the title policy in effect, and it provides maximum flexibility in the management of your affairs. The other interesting point about trust is if you have your home in a trust, for example, It will escape any claims by Medi-Cal should you ever have to use Medi-Cal to help supplement your health care. If it's not in your trust, then Medi-Cal, state of California, will have a claim on the real property. So there's also something called transfer on death deed. This is new. I'm not really recommended at this point because title companies are not real comfortable with it, and you want to make sure you can get a title insurance, but it applies to certain kind of real estate, condominiums, not more than 4 units, but it's on the deed. You actually put on the deed, on my death, this real estate goes to Mary or Sam. So it's something to look into if that interests you. Joint tenancy, people always want to think about, I always do think about joint tenancy because it's easy. And there are advantages and disadvantages. The advantages of joint tenancy is avoid probate because there's a right of survivorship. If somebody passes away, the survivor automatically gets that property. It may avoid creditors of the deceased joint tenant. So if you have a joint tenant, a lot of debts and claims against that joint tenant, they pass away, the property is free and clear of those claims. It's easy, inexpensive. Married couples should consider non-trust assets to be held as community property with right of survivorship, and we'll see why. Disadvantages: if your spouse is your joint tenant, at your death, your spouse's interest in the property will not receive a step up in basis. This is important tax planning for you. Property that is held in California is only like 8, 10 maybe states that are community property states. If you own it as community property, there's a 100% step up in the basis. So if you bought rental property for $300,000 and you own it as community property, and one of you passes away when it's worth $1 million, the survivor can sell it for $1 million, income tax free. If it's held in joint tenancy, only the decedent's half gets stepped up, and there'll be a capital gain. So it's important to do that. So that's why we never recommend spouses to hold things to joint tenancy, with appreciable assets and community property with right of survivorship. Also, if your spouse is your joint tenant, it's incompatible with estate planning. You may want to provide that your children from a previous marriage might get a share of that property. Well, you can't do that if it's in joint tenancy or community property with right of survivorship. You can't do estate planning with it. And also it can increase his or her estate to the point where there's no more tax planning available and there may be an estate tax. Now, if the joint tenant is someone other than your spouse, that can be a real problem. You can't control disposition at death. So you may tell your joint tenant, if I pass away, I want you to share this property with my children. There's no way to control that. It's a taxable gift when you create the joint tenancy. So if you own a property and you want to add somebody to it as a joint tenant, that's a gift. You may have to file gift tax returns. And your joint tenant can transfer the interest to their spouse, to their children, to a stranger. They can sell it, they can pledge it. You have no control over that. And it's not a good idea to put property joint tenancy with your children. We do have clients that say, I can avoid, my major asset is this house or this rental property, and I don't want to trust, I can just do joint tenancy. But no matter how good your kid is, he or she could get into an accident, take out a school bus, get sued for $10 million. Maybe they don't pay their income taxes like they should. And your house is at risk. So your property will pay for those creditors, and you want to avoid that. And also, if your joint tenant should pass away before you, the value of that half is in that person's estate, could create a tax situation. So you can, they can also, your joint tenant, if you have a bank account, investment accounts, and you just put somebody on as a joint tenant, they can take all the money. They can spend it all. Again, the creditors can claim it. The IRS can claim it. They can spend it. They can give it away. You just lose a lot of control. And it's something we don't really recommend. There's other better vehicles than joint tenancy. So one is trust. And we'll talk about trusts. Trusts are great. They're not that complicated, and they can enable you to provide for incapacity, so you can avoid the conservatorship. You can control disposition of your estate at death, management after death. You may want to have some assets stay for someone's life and then go to others. You may want to provide that funds are doled out as people become certain ages. You can control these things. Also, it's very important to consider family dynamics in choosing your fiduciary to handle financial affairs. If you become incapacitated, you and your spouse can no longer handle being a trustee, someone's going to take over. And that's a lot of conversation. Is it just going to be your oldest child, who may or may not be that competent to do this? It could be the youngest one. Are there going to be hurt feelings? What if you have 4 or 5 children and you name 2? How are the others going to feel? So a lot of thought has to be given to the family dynamics. And many people, quite frankly, would rather keep their family intact and everybody get along well, which is more important to them than even who gets what, when, and where. So that's an important part. You want to avoid probate, which trusts do, and you can minimize or even eliminate estate taxes. So it's an easy matter to set up. It really just try to get a picture of it. The trustor is the person who sets up a trust. So if it's you and your spouse, you're trustors. That's what you're called. And you have assets. And you transfer the assets to yourself. You're the trustee. Transfer yourself. You hold it, administer, distribute for the benefit of yourselves and ultimately to your beneficiaries, which may or may not be your children. So you just transfer to yourself. It's not this doesn't avoid taxes. It's not going to protect you from liability. It's to avoid probate and to avoid conservatorships. That's the basic purpose of a trust. And there's 2 kinds of trust, really. There's a revocable trust, which you're mostly all aware of. The trustor can amend or revoke at any time before death. There's no tax or asset protection during a lifetime. Then there are certain irrevocable trusts. And once you do that, you can no longer amend it or revoke it. It's a completed gift for gift tax purposes, but it may have some income tax and asset protection benefits. It's not done very often, very kind of rare occasions, but that is a second type of trust. So estate planning, the basic estate planning with the revocable inter vivos trust, which is called a living trust or a family trust, and we'll see how that works. Okay, so here we are, trustors, Frank and Sally. They transfer assets to themselves, they're co-trustees. And they're the beneficiaries. They answer to nobody. They spend their money, they live their lives just as before. If one becomes incapacitated, the other just steps in and continues going. No real changes, nothing really happens. When one dies, the survivor is the sole trustee and the sole beneficiary, and just keeps on going, and life continues, and the trust goes on. And they also need, when you do a trust, a pour-over will. And a pour-over will is a special will where if you acquire some assets outside of your trust, you buy something out of state, you get a piece of property, you refinance your property, and the bank says take it out of the trust, but you never put it back in, and you have to probate some assets. The pour-over will simply says, in probate, pour this will back into the trust, so it all gets administered. But if everything's in the trust, you're careful with your bank accounts, your investment accounts, and your properties, pour-over will is never really used. Okay, so when the survivor dies, the successor trustee, again, financial fiduciary you picked. That could be professional trustees, that could be banks, it could be one of your children, brothers, sisters, relatives. They take over. And again, it's very important who that person is. And then the descendants become the beneficiaries. And the trust can direct the successor trustee to distribute specific items. Like I want my son to get grandfather's fishing pole or grandma's ring to my daughter, whatever you want, you can do that. And you can also divide it into shares to the benefit of the beneficiaries. If you have younger people, you're not going to give, obviously if they're 15, 16, 17, 18, you're not going to give them all the money. And the money is used for their care, their medical, their education, they need a car, they need clothes, whatever they need. Your trustee makes those decisions, what they get, when they get it, unless you're very, very specific, but usually we let the trustees have discretion. And then you can decide when they should be distributed the money. Maybe a third at age 22, 23, half of what's left at maybe 26, and maybe the balance at 30. Give them a chance to get assets and figure out how to deal with them. And other benefits, you can protect children from prior marriages. We'll see that. There is going to be asset protection in certain kind of trusts and estate tax savings. We'll show you a picture here. And here's a thing. You set up a trust, just like we talked about. You transfer to yourself, trustees. and you just live your lives and you spend your money, whatever. When one spouse dies, if you want to protect children, make sure you protect them from prior marriages. You want to maybe provide asset protection for your spouse who may be subject to, you know, creditors. You want to save taxes. You can do this. You split it. So on the death of the first spouse, the survivor gets a survivor's trust. The survivor's half a community property, all of his or her separate property. Do whatever you want with it. Give it away, spend it. The next gigolo that comes along, a bimbo that comes along, they can get it all. But then the decedent's half of everything, and all that decedent's separate property, goes in a special trust. You can name the surviving spouse the trustee, but that trust is irrevocable. It also is protected from claims of the survivor. It is asset protection benefit. The portion in this separate trust will not be subject to estate tax, no matter how much it grows. And it will guarantee where it goes. You know, if you want to guarantee children from a previous marriage, that will be guaranteed to go there. But the surviving spouse can have all the income, or even principal if he or she needs it. So this is the planning advice and something to think about in certain circumstances. Okay, so now we'll talk a little bit about Proposition 19 if you're going to be homeowners and you have homes. You may remember that the law was, until last year, that if you're 55 and older, you could transfer your property, your home, sell it, and transfer, and then buy something of lesser value, equal or lesser value, in the same county or in certain reciprocal counties that had agreements, and keep your property tax base. That was very important for seniors. Now we have a law that says you can use any county, and you get the 3 transfers in your lifetime. Before it was 1 transfer, now it's 3 transfers, and you could sell your house in Santa Barbara County and go to San Marin County and carry your property tax base. So it's transferred to your new home up to the value of your old home. Previously, if you bought a house for more money than you sold your old one for, you did not get to transfer any of your property tax base. Now you can transfer your property tax base up to the value of your old home, but the new amount will be taxed. The amount over will be taxed at regular rates, and you have to do it within 2 years when you sell your old home. And the bad. Okay, county will increase the property tax base to the fair market value if the child does not use the residence. Now, this is also a change from the old law. The old law was if you transferred your residence on your death to your child, they had a parent-child exclusion, and they kept your property tax base, whether they lived in the house or not. They just kept your property tax base, plus $1 million of other assessed value. They could just inherit your property tax base. Now, the child is required to reside in your house and can carry the property tax base with them, what it was before, plus $1 million of fair market value, if they use it as their primary residence. So what happens, let's say you have a $2 million home, and its tax assessed, though, is $500,000. You pass away, and the child moves into the house. So the $500,000 tax base they get to carry, plus the next $1 million of fair market value. So $1.5 million just is taxed at the same rate, $5,000 a year, let's say. But the next $500,000 is going to be taxed at the normal rates. So the property tax actually is doubled. If it was a $500,000 tax base, the property tax was around $5,000 a year. Now it's going to be $10,000 a year. So it has doubled. And other property, after February of 2021, any property that the child does not live in will be taxed at its fair market value. There is no more transferring the parent's property tax base. There was a lot of transfers going on before February 21, 2021, but used the parent-child exclusion, but that doesn't exist now. And the purpose of it is kind of interesting. The purpose of it, well, when you think about it, there are some homes in like Malibu that have been in families for 30, 40, 50, 60 years that the parents may have paid really little for, that are now worth $10, $15 million. But in the past, the children can get the property tax base, which might have been, $5,000 a year, $10,000 a year, but they could rent these things out for $30,000 a month. Now the property tax on a $20 million piece of property will be $200,000. So it discourages generations just to keep these valuable pieces of property. And so they are selling these things more because property taxes will increase dramatically. So in sum, the estate planning is important for all of us. We don't know when we may get hit by a bus or hit by lightning. Somebody has to take care of financial matters. Someone may have to make healthcare decisions for us. We may have certain wishes that we want carried out if we become ill, and that can all be handled. Plus, you want to avoid probate, trusts are private. You sit in the lawyer's office, you divide up the assets in a certain way, and nobody knows. And it's quick and it's relatively painless for the family, and you avoid a lot of problems. So that's the presentation for today, and I thank you very much for your attention. And you can certainly contact us if you have any questions.